विद्यार्थियों, let us start. First of all, we read the quotation. अपनी शक्तियों पर भरोसा करने वाले कभी असफल नहीं होते. The person who believes in himself never defeat, never fail. So first of all of us should believe themselves. Now the first question. A is tried for murder of B by intentionally shooting him dead. A is tried. A is tried for murder of B by intentionally shooting him dead. The fact that A was in the habit of shooting at people, A was in the habit of shooting at people with intent to murder to him. Is relevant, is irrelevant, is relevant but cannot be proved, none of the above. Actually, the question is based on illustration O of the section 14 of Indian Evidence Act. In this question, it is asked the habit of shooting at people with intent to murder. Here, explanation first of section 14. Particular mind or intention must be required to commit any offense, not in general. Whereas section 14 says that state of mind, state of body, bodily feelings are relevant. But state of mind what? State of mind must be particular. With reference to particular intention, it must not be in general. It is said in the explanation first of section 14, and it is also mentioned that general view, general intention, when the intention is general, not particular, that shall not be relevant. Here, the person was in the habit of shooting. In the habit of shooting, he did not want to commit murder to particular person, that is B, but he shoot in the habit of his. It means it is his habitual act. So the line shall be irrelevant. So the answer B shall be correct. Okay? This is the correct answer. Irrelevant. Next question. A is tried for the murder of B by intentionally shooting him dead. Okay? In trial the irrelevant fact. What the fact is irrelevant? Let us see. A was in the habit of shooting at people with intent to murder them. This is the irrelevant. Why? In the habit of, he commits such act in the habit of. So when the habit is mentioned, such act shall not be relevant, that is irrelevant, and in the question it is asked relevancy. Whether it is relevant or not, it is irrelevant. So any act when committed, that act shall be irrelevant. When the act was committed in the habit of person. So A is the correct answer of question number 2. Next question. X sues Y for damage done by a dog of Y. It means Y is the owner of the dog, supposing that, and the dog bites X. Okay, so the person X gets injured and sues against Y. So X sues Y for damage done by a dog of Y. Okay, which Y knew to be ferocious. Y knows that dog was ferocious. The fact that the dog previously beaten A, B, and C are relevant because the dog bit A, B, C also. So, according to it, Y knows his dog was ferocious, and if the dog bites X means you against Y, and so the fact that the dog previously beaten A, B, C, it shall be relevant. So the correct answer is of the question. Question number 4. A is accused of defaming B. A is accused of defaming B by publishing an imputation intended to harm the reputation B, showing ill will on the part of A towards B is relevant. Showing ill will on the part of A towards B is relevant. Again, A is accused of defaming B by publishing an imputation intended to harm the reputation of B, showing ill will, okay, on the part of A towards B is relevant under state of mind. Why? Section 14 says that any fact that is state of mind, state of body, bodily feeling. These, if any fact is connected with fact in issue, are relevant fact under these process, under these connection, by which state of mind, state of body, bodily feeling, such fact shall be relevant. So, and state of mind includes ill will also. So, ill will shall be relevant. Here the question is relevant. Yes, it is relevant. But why? How? Because it proves the preparation for harming a reputation. No, this is wrong. It is not preparation. As it is necessary to explain fact in issue, as proving intention to harm B's reputation, as it is the effect of relevant. Here the question intended to harm the reputation B, showing ill will on the part of A towards B is relevant. Ill will is relevant. Why? It is not preparation. So A is wrong. As it is necessary to explain fact in issue. It is necessary to explain fact in issue. It is essential to explain what? Ill will. Ill will is necessary to explain fact in issue. This is mentioned in option B. Next, as proving intention to harm B's reputation. Okay? So, the correct answer of the question is, of this question, the correct answer shall be C. As proving intention to harm B's reputation, because if ill will is showed by A, ill will is connecting with the state of mind under section 14. It means state of mind includes ill will, fraudulent, intention, etc. All these things are included. So, if any intention of the person is to be shown, then ill will may be produced as an evidence. So, the correct answer of the question shall be C. Next, which of the following does not find a mention as showing a state of mind under section 14? I have told you, section 14, any fact if connected as state of mind, state of body, bodily feeling with the fact in issue are relevant fact, such fact shall be relevant. So here a fact which of the following does not find a mention as showing a state of mind under section 14 of the Indian Evidence Act. Ill will, it is also a state of mind. Motive, if you study para 1st of section 14, motive is not present. Motive is not included in state of mind. Actually, motive is propounded in the section 8 of Indian Evidence Act. So, here motive is not included in the section 14. Ill will is included, motive is not. Good faith is also included, negligence is also included. Here the question does not find a mention. So the correct answer shall be motive, because motive is not included in the term state of mind. So the correct answer of the question shall be B. Okay? Next question. The facts showing the existence of any state of mind under section 14 of the Indian Evidence Act relate to intention, knowledge, good faith, all the above. State of mind includes all of these things: intention, knowledge, good faith, ill will, fraudulent. All these things are included in the state of mind. So the correct answer of the question shall be D. D is the correct answer. Okay? Next. Which one of the following statement is not correct? Not correct. Focus on not, on the term not. What is said? Not statement is not correct. Facts showing requisite, the state of mind are relevant. Yes. Evidence can be given of every fact from which the state of a person, bodily feeling can be inferred. Yes. Evidence can be given of facts as will prove general state of mind. General state of mind. Oh, here the following statement is not correct. And option C says that evidence can be given of the facts as will prove general state of mind. In the section 14 explanation first says that state of mind must not be general. It should be particular, special, specific, not general. If the state of mind is general, that shall be irrelevant. So the correct answer of the question shall be C. Because general state of mind of a person, state of mind of a person, state of mind must not be general. It must be particular, special. So the correct answer shall be C. C shall be correct answer. Okay? Next. Under which one of the following sections of Indian Evidence Act previous conviction of a person is relevant? When the question is asked relating to previous conviction. Explanation second of section 14 says that. Explanation second of the section 14 says that what? Previous conviction, evidence of previous conviction may be produced as an evidence. If previous conviction is asked in the trial, question of previous conviction is asked, then previous conviction of a person shall be relevant under section 14. Under section 14 of the explanation second. This is the correct answer. It shall be the correct answer. Okay. Question number 8. The correct answer shall be B, because explanation second of section 14 tells about the previous conviction may be produced as an evidence. So the correct answer of the question number 8 shall be B. Okay. Next. A is accused of fraudulently delivering to B a counterfeit rupee. Counterfeit rupee. The rupee is not correct. The rupee is false, forged. The question is whether the delivery of the rupee was accidental or intentional. This is the question. And section 15 says that. Section 15 tells about it. But first of all, we read the question. The fact soon before or after, whether before or after the delivery to be A delivered a counterfeit rupees to C. And D, E, counterfeit rupees have been delivered. B, C, D, E, F, G. It means if A delivers counterfeit rupee to B, it is not accidental. It shall be intentionally under section 15 of the Act. So the correct answer shall be 15. Sorry, C. 15 not, section 15. According to the section 15, the correct answer shall be C. 15 of the Evidence Act. This is the correct answer. And according to it, the delivery of counterfeit rupee is not accidental, but it is intentionally. With intention, the counterfeit rupees was delivered. Okay. Question number 10. The brides in Bath case is based which section of Indian Evidence Act? R versus Panchudas, 1920 Calcutta High Court. In this case, Justice Sampson says that, or you can say that the particular case R versus Panchudas, Justice Sampson termed this case what? The brides in Bath. He termed the case he gave a name, the bride in bath. Which case? R versus Emperor versus Panchudas. So it was mentioned in the section 15, or you can say the particular case is relating to section 15, and while the judge was deciding the case, he termed the name particular case the brides in the bath. So it is connected with section 15, and the case was Emperor versus Panchudas and Justice Sampson, Court, Calcutta, year 1920. Remember it. Okay. Next question. Question number 11. The question is whether a particular letter reached A. Whether a particular letter reached A. The fact that it was posted in due course and was not returned through the dead letter office. It was not returned. Dead letter, as a dead letter. It means the letter was posted properly. When the letter was posted properly and it was not returned as a dead letter, the law presumes that the letter reached to A, and it is mentioned. The principle is described in the section 16 of Indian Evidence Act. It was described. So the dead letter office, it shall be relevant. Shall be relevant. The question, first of all, study. The question is whether a particular letter reached A. The fact that it was posted in due course and was not returned through the dead letter office, it was relevant under section 16. It was posted in particular, whether a particular letter reached A. It was relevant under section 16 because according to section 16, it is presumed that the letter reached A if the letter was posted properly and was not returned as a dead letter. According to section 16, law presumes the letter was reached to A, so it shall be relevant under section 16. Option C shall be correct answer. Okay. Next. Which one of the following sections of the Indian Evidence Act defines admission? Students, it is very clear. Section 17 defines the admission. So the correct answer shall be B. Okay. Next question. Which of the following sections was amended by the Technology Act 2000. Which section? Which section was amended? Section 17. Under following this section, section 6, 32 and 41 was not amended. But section 17 was amended by the Technology Act 2000. So the correct answer of the question 13 shall be B. B shall be the correct answer. Because Technology Act 2000, through this amendment Act, section 17 was amended. So the correct answer shall be B. Okay. Next question. Which one of the following statement is correct? Which one of the following statements is correct? Admission can be oral only. Only the term is incorrect. Oral, maybe documentary. It means not only oral, not only documentary, not only in electronic means, but it may be oral, documentary or electronic. So the answer of the question shall be C. C shall be the correct answer. Admissions can be oral or documentary. Not only oral, not only documentary, but it may be oral or documentary. Okay? So C shall be the correct answer. Question number 15. Which of the following statement is not correct regarding admission under section 17 of Indian Evidence Act? Which of the following statement is not correct? Which of the following statement is not correct regarding admission? Okay, under section 17 of Indian Evidence. First one, admission operates as waiver of proof. Waiver of proof. Next, admission is a statement which is necessarily against one's own interest. Necessarily against. It means all the admissions are against the person making admission. Necessarily. If necessarily all the admissions are against the person making admission, then section 21 what says? It means the term necessarily is not correct. So answer not correct. The correct answer is not told. We have not tell. Incorrect. Not correct. Incorrect. Which option is incorrect? That option shall be correct according to the question. So, which of the following statement is not correct regarding admission under section 17 of Indian Evidence Act. It means admission operates as waiver of proof. As waiver of proof. Next, admission is a statement which is necessary against one's own interest, not necessarily against. This term should not be, if it is used, it means the option shall be incorrect. And which option is incorrect, that option shall be correct. Because the question not correct option. So B is incorrect. A is, let us read, A statement which suggests some inference as to fact in issue, relevant fact, may be admission, correct. It is generally irrelevant as to whom all admission is made. Actually, the option B shall be correct answer of the question. Why? Because all the admissions are not necessarily against the person making admission. Some admission, according to section 21, may be in the interest of the person making, or you can say are not against the person against to the person making admission. So it may be used as an estoppel. It may be binding. It may be binding. So correct answer of the question 15 shall be B. Admissions bind the maker in so far as it relates to facts. It is a conceptual question. Students, learn it. This question is very technical. Why? Because admissions bind the maker. It means the person who makes, the person making admission. Admission shall bind to those person. Okay? In so far as it relates to fact. Why? Section 17. If you study carefully section 17, admission is always connecting with the fact, not law. Fact. And read with it, in section 17, read with section 31. Admissions are not conclusive proof. It is only estoppel. It may be used as an estoppel. It means binding to the person making such admission. If you study section 17 with section 31, the conclusion is, or the conclusion shall be, admissions that is relating to fact shall bind the person making such admission. Because the admission is relating to fact. And when any admission is relating to fact, that shall bind to the person making such admission under section 31. So the correct answer shall be A. Okay? correct answer shall be A. A very technical question, actually. If you know the Philosophy of Evidence Act, or you can say Section 17, then you shall be capable to answer this like this question. Okay? Next question. Under the provisions of the Indian Evidence Act, admissions and confessions have the same meaning. Under the provisions of the Indian Evidence Act, students, this question is also ambiguous. Why? If you study only the provisions of Indian Evidence Act, as the question is asked, it means if you study Section 17, where the admission is defined, and regarding to admission, statement of Sir Stephen, if you study, you find that there is no difference between admission and confession. But in 1939, if you see that the case Pakla Narayan versus Emperor, in this case, confession is defined by the Lord Atkin. And here, Sir Atkin differentiate admission and confession. According to the provision of Indian Evidence Act, according to the provision of Indian Evidence Act, so if we see carefully, the answer shall be there is a distinction, there is a difference between admission and confession. But according to the provision, if we carefully study, there is no difference, there is no much difference. So, what will be the answer? I would not like to make you confused, but this type of question may be asked. Let us start reasoning. Students must be careful. Whatever Lord Atkin defines the confession, that is based on the provisions of Indian Evidence Act. So, the correct answer shall be, according to the provision, there is a difference between admission and confession. Okay? So, the correct answer shall be, admission and confession have the same meaning? No. Admissions and confession have the different meaning? Yes. Admissions are matter of criminal trial? Wrong. Confessions are matter of a civil trial? It is also wrong. Why? Because admission is relating to criminal as well as civil, the both. It may be criminal, it may be civil. It is not only civil or not only criminal. it may be civil as well as criminal, but confession is relating only and only to criminal. Okay, so the option C, D is incorrect, A is also incorrect. The correct answer of the question 17 is B. B shall be the correct answer. Okay. Next. Thank you. That's all. Okay, thank you. That's all.